I'm Lynn Packer. This is an in-depth look at a dysfunctional Utah HOA. A homeowners association is the organization for a subdivision that makes and enforces rules for the residents. Home buyers automatically become members. They're under contract to pay HOA fees and abide by the rules, most of which are more restrictive than city ordinances. HOAs have boards of directors who are elected to enforce and oversee the rules and regulations that are outlined in a document called the Declaration of Covenants, Conditions, and Restrictions, the CC&Rs. At first, the developer, also called the declarant, selects directors and controls the HOA until transferring that control to the homeowners after selling a predetermined number of lots. There's two key words: declaration and declarant, the one who files that declaration. Utah has more than 2,000 single-family homeowners associations like Hill Farms. The state's legislative and executive branches favor developers, the declarants, who form and initially control HOAs. HOA homebuyers and members get the legislative and administrative snub. Thus the warning, buyer beware. Utah is a breeding ground for corrupt HOAs. There is no HOA ombudsman in the Consumer Protection Division, no dedicated prosecutor in the AG's office, no mandatory independent financial audit law, no managing agent licensing, that is, the managers of HOAs don't need to be licensed. There's no required declarant conflict of interest disclosures, no mandatory termination of declarant control. Here's the Hill Farms HOA debacle in bullet points. The Hill Farms HOA, still under developer declarant control, operates mostly in secret, making it difficult for members to detect possible financial mismanagement or fraud. The Hill Farms Homeowners Association, HOA, board of directors, and officers often violate their contractual and fiduciary duties. The directors fail to hold legally required board meetings. The HOA managing agent that the board selected has a history of committing fraud, and an accused perpetrator is still with the company. The HOA's managing agent fails to carry employee dishonesty insurance as required by its contract with the HOA. Here's an aerial view of the subdivision. The extended Hill family sought a developer who would turn 100 acres of pasture land into a well-designed subdivision. They chose Destination Homes Incorporated of nearby Layton, Utah. And about here is where our home is located. The Hill Farms concept was designed by Pittsburgh's renowned architect company, Urban Design Associated. It features pedestrian-friendly, walkable streets, public open spaces, neighborhood parks, and pathways. HOA members, of course, are financially responsible for keeping up the common areas. The home style is colonial revival, with garages set back, often accessed from back alleys to emphasize traditional design, which my wife and I really like. And it has higher than average landscape and upkeep standards, and those are to be enforced by the HOA board of directors. Two companies gave birth to the Hill Farms HOA. One, Destination Homes, the developer. The other, Golden Land Management, Inc. It's sort of a subsidiary of Randy Marriott Construction Company. The two joined together and formed Legacy Neighborhoods, LLC in September 2013. It controls the HOA and formed the HOA, Hill Farms, in October 2013. There's another company that's involved, Community Solutions and Sales, or CSS. That's the managing agent, the company that manages the HOA. So here are the main players in photographs: Brad Wilson, David Bailey of Destination Homes, selected by the Hill family to build the homes. Then they partnered with Marriott's Golden Land Management to buy land and to construct water and sewer infrastructure. Randy Marriott has a construction company, and they invested in property. And again, his wife, Cammie, managed the company. Then Becky and Jeff Wheeler, their company is the one that manages the HOA. They were chosen by Destination Homes to do it. And then they have an employee who's assigned to this particular HOA, Suzette Thomas, and there also is an attorney, Blake Johnson. Now, he was selected by Legacy Neighborhoods to be legal counsel. He works with the managing agent, but is an attorney for the HOA itself. The Hill Farms Declaration is the main governing document. As I mentioned, it's also called the CC&Rs. Here's the top of the document that was filed, and it was recorded in 2013 by Legacy Neighborhoods, LLC. It's a document that is one-sided in the developer's favor. There's another set of records, the Hill Farms HOA bylaws. It's, like I said, another governing document. It requires the creation of a 3-person board of directors and officers, president, vice president, and secretary treasurer, and the officers and directors may be the same people. The board must meet at least once a year and take minutes. That's, is required in these bylaws. It was recorded, the bylaw document, 3 years late in 2016 in violation of Utah law, and is already showing some of the real sloppiness associated with this HOA. It gives full control to the declarant, and the declarant is called in the document the Class B member, although they're really treated more like Class A members, and that's Legacy Neighborhoods, and that goes on until control is passed to homeowners. And the homeowners are called Class A members, and they remain Class A members are not in control until most, if not all, the houses are built. And again, it's one-sided in the developer's favor. The Hill Farms HOA Board of Directors were selected by the declarant Legacy Neighborhoods. And the initial board was selected at the outset, and it was David Bailey and Brad Wilson with Destination Homes and Cammie Marriott with Marriott Construction. There's a current board right now, but the HOA won't disclose the names of who's on the current board. But checking records that are online, it appears to be just Destination Homes personnel who are now on the board: Jeremy Farrell, David Bailey, and John Warnick. But what's clear is Legacy Neighbors ceded control to Destination Homes, and Destination, not Legacy, calls all the shots during this period of declarant control. I made numerous requests for board member names, one in an email to Suzette Thomas. Don't you already know the names of HOA board members and their contact information? I keep asking and have yet to get an answer. She responded, at the current time, Destination Homes, the declarant, acts as the board of directors and as the governing body for the Homeowners Association. As you can tell, she dodged the question. Destination Homes is not the declarant. Again, it's Legacy Neighborhoods. How is it that the HOA manager didn't know who the declarant is, and why the deception and secrecy? Hill Farms HOA board member names, qualifications, and duties are supposed to be in the bylaws. That's what the bylaws say. The number of board members, the title, how they're elected, their qualifications, powers, and so on. They're not in there. That's in violation of Utah law. I called CSS President Jeff Wheeler I asked him who directs the Hill Farms HOA. He said that would be the executives at Destination Homes. What are their names? I don't know who's on their board. I'm sorry, but some of these executives, they hire us so that they don't have to deal with the HOA. They don't want to have dialogue or discussions. They do not want to be contacted. I figured out that the declarant, Legacy Neighborhoods, is just a shell. Now, shell companies, they can have legal operations and illegal operations, but how do you tell if it's a shell? Does it have an office building address? No, the address is the Marriott family home in Plain City. Does it have employees? None that I could detect. Does it have a phone number and website? No. Does its board meet and take minutes? No. Has it filed annual reports with the state? No, as well. Does it have a Kaysville city business license? No, it doesn't even have a license to operate in the city where it runs an HOA. How should the Hill Farms HOA board function? Is it a real board? Well, a real board has notices of board meetings, agendas. The meetings are open to members, they take minutes, and they have easily accessible records. But is the Hill Farms board a fake board? Well, it has secret random meetings, as if a meeting around a water cooler. Here's what the facts show about the HOA's phantom board. Destination Homes, not Legacy Neighborhoods, took control of the HOA and created an illusionary board of directors. The board exists mostly on paper, not in reality. The board held at most one of the 6 minimum required annual meetings, and even that one is suspect, as we'll see in a second. Most HOA actions have been decided behind closed doors, without notifying members, without publishing agendas, without Class A member votes, and without taking minutes. The board ignores the bylaws provision that homeowners have the right to attend board meetings, ask questions, and cast votes. Directors have expected homeowners to abide by the contract while they breach it. Now, HOAs in the state of Utah are supposed to file with the state, so people can go online and see if it's a registered HOA. And they're supposed to disclose in the filing the name of the board president. Hill Farms filed that information 2 years after the filing deadline mandated by law. More sloppiness on the part of the HOA. Its current registration contains false officer information in violation of the law, but the state has no mechanism to enforce that law. Here's the Hill Farm state registration. It's online. And its original date, as I said, was 2015, 2 years late. And the latest modification or addition was in 2018. And right on the website, it says, please be advised, knowingly providing false information to this registry is a Class B misdemeanor. That's a criminal offense. But as I said, there is really no enforcement set up. The registered chairman is listed as Cameron Scott on the website. And again, this website was updated about a year ago. But here's the problem, is he left Destination Farms a year before the filing in 2017. He was gone that year when he was listed as board chairman. He told me he never chaired a board meeting. He says no formal board meetings were held or minutes kept. He says that the board did not want interference from homeowners. I'd like to quickly mention another possible Hill Farms HOA fandom board member, Janae Reed. Here she is listed on a corporate filing as director. She was a CSS Management Company agent director at the same time she was a Hill Farms HOA director. It's a glaring conflict of interest. So here's the question: if there's no actual board, has the HOA been collecting dues illegally? There's an interesting legal case in Georgia where the developer never actually appointed a board. Rather, the developer itself levied the assessments. The Court of Appeals ruled that the developer is not permitted to stand in the shoes of the board as to assessment powers. The court concluded that in the absence of any board, there was no authority to levy assessments. So what about the Hill Farms case? The declaration does give the board power to collect fees and to delegate that authority, but did the board ever legally exercise that power? There are no minute records showing any vote by the board and members. The developer, Destination Homes, has been standing in both the declarant's shoes and in the board's shoes. So you'd conclude there is no officially constituted Hill Farms HOA board. The developer's managing agent all this time has been looking the other way. So let's take a look at the management company, CSS. Again, Becky and Jeff Wheeler own the company. Their representative to Hill Farms is Suzette Thomas, and Blake Johnson is the Hill Farms attorney. And those two have been my primary contacts for records and answers. CSS has a managing agent contract with the HOA, but they've been performing unauthorized duties not laid out in the contract, and they have failed to perform some contracted duties that are in that contract. Unauthorized work is involvement with the landscaping plan approval process. There's no authority given to them to do that. They were given authority to do other things, but those are omissions, things that they've been paid to do but haven't done, such as preparing agendas, notices, and ballots for annual board meetings, attendance at annual board meetings, and maintaining employee dishonesty insurance, and also maintaining association real estate values. They're the ones that are supposed to enforce the rules that keep up the value of property in the HOA. They're also supposed to be soliciting vendor bids. There are warnings about Utah HOA companies, some of them issued by the Morris Sperry HOA law firm in Utah. Here's what they say. Amazingly, HOA management companies are completely unregulated and do not need any license. They can accumulate and manage millions of dollars in assessments and reserve funds without any state oversight. In Utah, there are fewer qualifications for managing HOAs than there are to do nails in a nail salon. A person could finish a 10-year prison sentence for embezzlement and fraud and start managing an HOA the next day, taking over control of hundreds of thousands of dollars of unknowing homeowner funds. Thefts have occurred in Utah HOAs multiple times. So here's an overview of HOA board and CSS dysfunction. The board and its management company refused to provide all legally required records. The HOA's website lacks key information required by law. Secret and missing records could conceal serious financial problems. Managing agent CSS was successfully sued by another HOA in connection with an embezzlement scheme. Initially refused in that case to provide records. The employee accused of embezzling is still with CSS. The HOA board and its manager failed to enforce HOA rules consistently and fairly, and the developer violates association rules itself and is not cited by its managing agent, CSS. Let's look again at the HOA contract and the CC&Rs. Remember, these are the declaration of covenants that were recorded with the Davis County Recorder's Office. So here's what it says about HOA managers and directors, and gives them the contractual obligation to establish covenants and rules. They must enforce the CCNRs and keep records. They must act in the homeowner's interest, not their own, called the fiduciary duty. They can require dues payments and fine owners. They can abate violations and require homeowners to pay costs. They can even file liens and take homeowners to court. But what about the homeowners and members? They must pay monthly dues under the contract. They must comply with the CCNRs. They can examine records and collect fines for the board's failure to provide records access. And they can sue the HOA for breach of contract, for breach of fiduciary duty, and for mismanagement of funds. There's a Hill Farms website, and it outlines the rights and responsibilities. And anyone can go to this website and see documents that they've made available there, along with other information. And this is what the website says about homeowners' rights, that they can expect honest and fair treatment by the community leaders and managers, that they can participate in meetings and serve on committees, stand for election, that they can access appropriate association books and records. Leaders and directors have rights as outlined on the website. They can expect owners and non-owner residents to meet their financial obligations, and expect residents to know and comply with the rules and to stay informed about the association. Homeowners' responsibilities, they need to read and comply with the governing documents, maintain their property, treat association leaders honestly, vote in community elections, and pay the assessments on time. Now, this is the one I want to focus on. Again, this is on the website, the leaders, managers' responsibilities, because these are all problematic. They are to fulfill their fiduciary duties to the community, exercise discretion in a manner they reasonably believe to be in the best interest of the community. That's a red flag. They have not been doing that. Another one, and again, this is their information that they've provided. Establish committees or use other methods to obtain input from owners and non-owner residents. They've not done that. Conduct business in a transparent manner and allow homeowners to access appropriate community records. Again, a failure. And provide complete and timely disclosure of personal and financial conflicts of interest. Absolutely not done. Let's now take a look at some Hill Farms HOA enforcement failures. And many rules were not enforced at all. Some rules have been enforced, but unfairly. Utah law requires fair, non-selective enforcement treatment. The code says the board may not be arbitrary, capricious, or act against public policy. It also says a rule shall treat similarly situated lot owners similarly. That's the law. And HOA attorney Curtis Kimball has talked about it. Said one of the most common sources of lawsuits in associations is the failure of the board to know and abide by the governing documents and the law. The duty to treat members fairly requires consistent application of the rules. A board cannot selectively enforce a rule against one resident and ignore the same violation by another resident. Another HOA attorney, it is critically important that you comply with the declaration, bylaws, rules, and other documents governing your association. And he's directing this to board members. When you deviate from or ignore these documents, you can cause legal problems both for yourself and the association. You have a fiduciary duty and other legal duties to the association. So, beginning with illegal signs, These are enforcement failures by the HOA. The HOA has a strict restriction on signs. Only a few signs are permitted. But here are some violation examples that were not dealt with by the HOA and its management representative. I'll just pop a few of them up here where there have been violations. All across the community. Another enforcement failure, the cedar fence rules. Only picket or double rail wood fences are allowed. Only bleach gray or brown stains are permitted, not white. Here's the rule. And they even go so far as to tell you exactly the product and which stain to use on the wood fence. Here's some violation examples. Here's a picket fence that was painted white, not stained with the required finishes, yet it was approved or permitted by the ARB. Here's another fence that's been stained dark, and it's right across from the model home where Destination Homes officials would see it daily. Then there's the home of Destination Homes co-founder Kevin Bailey. His cedar fence, he lives in the association, has both an unauthorized design and color. It's neither two rail nor picket, and it's white, not weathered gray. If you go through the association, it's the only fence that looks like that. So I wondered about that, and I asked for to get a copy of the application he used to get a non-compliant fence. And I got a letter back from the attorney, and he denied access. This is what he said. This request does not appear to be suited for any particular good faith purpose presented by you, and is not a document which is atomically, I think he means automatically, subject to inspection. It would be an interesting document to see, and I wonder if it even exists. Here's a yard art violation example that any yard art has to be compatible with the character of the community. And yet they allowed someone to put a washing machine in their yard as part of their landscaping. There's a rule about tree rings. It says you've got to have a mulched area around trees, and it has to be consistent with the edging that's in the rest of the yard. Most trees in the subdivision violate the rule. Even Destination Homes model home violates the rule. Rules about playground equipment, that play elements have to be submitted for approval. They're only allowed in rear yards and must be hidden or screened from public view. Let me repeat that. They have to be hidden or screened from public view. But everywhere in the subdivision, you see trampolines, swing sets, basketball goals, and these two are lots right next to the model home for Destination Homes. And there are many others, like I said, all over the subdivision. Now, they did provide me with some site visit reports, and here is one taken from 2019, and in the report, it talks about, and it has ongoing notations of playset violations, yet no corrective action was ever taken. These are really token inspections where they note something and nothing is done about it. There's a maximum 75% lawn rule. It can't exceed 75% of yard coverage, but virtually every front yard that Destination Homes installs as required by Kaysville City, breaks that rule. And many homeowner-installed side and backyards the destination approves or permits break the 75% rule. Here's a couple of examples. There's a destination-installed front yard that has more than 75% grass and no other landscaping. Here's one that was done by a homeowner. Here's the risk. Many Hill Farms HOA rules are in danger of becoming unenforceable if deemed legally abandoned. This is the Utah Supreme Court's abandonment test. In simplest terms, this test is met when the average person, upon inspection of a subdivision and knowing of a certain restriction, will readily observe sufficient violations so that he or she will logically infer that the property owners neither adhere to or enforce the restriction. And there's financial consequences when rules are abandoned. The lack of covenant enforcement not only impacts the appearance of a community, but also adversely affects the property values. Many people view their HOA as desirable organizations that prevent property values from dipping. The volunteer-governed organizations, which regulate everything from holiday decorations to grass height, enforce rules and protect residents' property values. Covenants are designed to enhance the value and marketability of property. They are intended to be binding conditions of mutual benefit to both the grantor and the grantee. There's yet another Hill Farms HOA fiction, and that's its Architectural Review Board, known as the ARB. All homeowner landscaping, among other work, has to be approved by the Hill Farms ARB. Here's what it says. The owner shall submit a landscaping plan to the ARB and receive approval of said plan prior to commencement of any such landscaping. The HOA and its manager make numerous references to an ARB, yet no homeowner has ever contacted the committee or even knows its members' names. The HOA tries to create the appearance there is an ARB. There is an ARB form. There's an ARB stamp. All applications are sent to CSS's Suzette Thomas, not to the ARB. And she doesn't even know the board member names. She says she emails them to a secretary. I asked CSS about its ARB involvement. Suzette Thomas said Destination Homes has contracted with Community Solutions to manage the application and approval process. But that's not true. Nowhere in their contract is CSS authorized or obligated to receive and process ARB applications. This is what the declaration says. The owner shall submit a landscaping plan to the ARB. In truth, there is no Hill Farms ARB. You just have to take a look behind the curtain. Just like with the full board of directors, an ARB does not exist. No names are ever disclosed. It's sort of like Toto pulling back the curtain, and that's sort of what I did. There's just a low-level developer employee whose name I had to decipher, Corinne Green. There's no record of her being appointed to be the ARB. There's no record of her deliberations, and no direct contact is allowed. Now about Hill Farms' failed transparency. It's neither open nor accountable to members. Nothing will sink your HOA board faster than secrecy, says one managing company. And a Utah management broker has written about it. Owners associations have long been required to provide access to HOA documents, finances, and meeting minutes to association members upon request. Unfortunately, some owners associations have not been quick to respond to requests. Given the potentially heavy penalties for failure to comply, it will be wise for all owners associations to carefully review their disclosure policies to ensure that they have a plan in place for speedy disclosures. And Just this footnote about the records providers, Johnson and Thomas. Getting many records has been like pulling teeth. There's still a lot I still don't have. Their client is supposed to be the whole HOA, not just the directors. Their primary loyalty, in my view, has been to the HOA's directors. I've experienced hardly any duty of loyalty they owe to us homeowner members. The Utah courts have an ethical rule for attorneys. It says if a lawyer for an organization knows that an officer associated with the organization is engaged in action that is a violation of a legal obligation to the organization or a violation of law that is likely to result in substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization. I don't think the HOA's attorney has been doing that. Here are some HOA record-keeping facts. All HOA records by law must always be available for inspection during the management company's regular business hours. The HOA can be fined $25 a day for failure to make certain records available within 5 days. CSS, the Hill Farms managing agent, has withheld key records not for days or weeks, but for months. Many required records do not exist due to the HOA's and managing agent's record-keeping failures, and other records that are being kept secret may be hiding mismanagement, even fraud. There's even an additional records requirement because the HOA is also a nonprofit. And here's the statute about that. It requires minutes for 3 years. And again, this is separate from other law, records of all actions taken by members without a meeting, and all written communications to members, and the list of current directors and officers. The law requires that board minutes be posted on the Hill Farms HOA's website. And there's the website. Minutes are among the most fundamental of HOA records. Minutes were not posted online, and most minutes were never even taken, so they couldn't be posted online. Now, CSS did provide 2 sets of minutes. That's the good news. Now the bad. Only one of 2 sets is for a board meeting. A minimum of 6, probably many more, should have been available. Even the one record does not contain any detail and required information. Taking a closer look at those purported board meeting minutes from March 2018, no one representing the declarant is identified. No president, vice president, or treasurer is identified in the minutes. The minutes say there's an advisory committee. There is no Hill Farms Advisory Committee. The minutes refer to minutes from 2 years previous that they were reviewed. It's likely those minutes don't even exist. So how did a single set of useless minutes even come about? Where did they get these minutes that they provided me? Well, the Hill Farms March 2018 minutes were created just days after the Utah legislature passed a bill requiring sellers of new and used homes that are in HOAs to provide the most recent approved minutes. Why? Real estate agents are required by law to disclose minutes to prospective home buyers. Many HOAs were not handing over minutes quickly and inexpensively, holding up home sales. So the one set of Hill Farms token minutes may please real estate agents, but are completely useless for checking an HOA's financial viability. Then there are records the Hill Farms HOA was required to make, but didn't. And these are admissions made in the June 10th letter that the attorney sent me. Now at the top of this box you see the record I identified that I wanted, and at the bottom in bold print is the HOA response. There are no additional board minutes than the one token minutes that they had provided. There are no ARB minutes. More admissions. No notices of HOA board meetings. No designation of board president, vice president, and treasurer. No financial audits performed. No required records retention policy. Only one of what should be several vendor contracts exist. And there are no records for competitive bidding or requests for proposals ever submitted. And here's just a side note. They did provide the one contract that CSS made with the landscaper. And when I was doing research for this, I noticed online that there's an endorsement. One of the CSS's employees endorsed the product. HOA managing agents should not endorse vendors, especially one that has a no-bid contract. And really, that landscape contract needs to be investigated. My view is that the admissions are additional evidence of breach of contract and breach of fiduciary duty. Now to the CSS fraud case that I mentioned earlier. I think it's a huge red flag. It really is a giant elephant in the room. Here's an overview. A Draper, Utah HOA had brought civil and criminal charges against CSS. CSS was sued for fraud, breach of contract, and breach of fiduciary duty. A criminal probe was also begun. The civil case settled in the HOA's favor. The criminal case was dropped after the statute of limitations expired. The police actually bungled the case. And the CSS employee who embezzled from the client, HOA, is still with the company. This history of this financial misconduct was not disclosed to Hill Farms HOA members. I would like to have known about it. How did it come about? Draper, Utah's Montana View Estates HOA director suspected CSS was committing fraud by stealing HOA funds. CSS refused to turn over key HOA records. So then the managing company unilaterally, after these requests were made, terminated its contract and records were returned to the HOA. That's required by law. After an audit, the HOA filed a criminal complaint with Draper Police and later filed a 2016 civil complaint in Utah's 3rd District Court. CSS refused to provide check endorsement records to the Montana View HOA. And here's the complaint and what the complaint said about that they wouldn't show the backs of checks and that they even met with CSS and their officers. They still would not produce the backs of checks to show who endorsed these checks. But then finally, the detective assigned to the criminal case obtained copies of the backs of the canceled checks that they got from the bank. And here is the fraud scheme. The Montana View HOA rules had a provision that homeowner culinary water could be shut off if more than 90 days behind paying their assessments. CSS hired a part-time worker to shut off water to homeowners behind in paying dues. Fake invoices were created, not by the worker, but by CSS manager Melissa Scott. In many cases, the HOA was billed for water not shut off. Sometimes the HOA was billed to shut off water for non-existent residences. In all cases, money paid via checks to the employed party was diverted to CSS manager Scott's bank account via deception and forgery. Here's an example of one of the forged checks. And here's sort of a flow chart to show how the scheme worked. The phony invoice was created and for services not performed by a friend of Melissa Scott's. Then that bill was submitted to the HOA for payment. Then the check was prepared and signed, I think generally by the CFO, Becky Wheeler, sometimes by her husband, the president, and mailed to the vendor in an address where HOA manager Melissa Scott would receive it. So it was mailed to the CSS manager, not to the employee that the check was made out to. And the vendor's name on the back of the check would be forged and the amount made payable to Melissa Scott's husband. Then it would be deposited in her bank account and then would eventually get to her. She admitted forging the checks. Her deposition was taken. She was asked about it and admitted in the deposition forging the checks. And it was after that that the case was settled in the favor of the HOA. But the admitted forger, embezzler, is still with CSS. She is still with the company. Now, CSS is supposed to be covered for employee dishonesty with what's called a fidelity bond or dishonesty insurance. And again, coming back to the contract that CSS has with the HOA, it requires this fidelity insurance. But when I inquired to get a copy of the insurance policy, I was told that they have no such record, that they're probably not insured for employee dishonesty. So CSS may be in breach of its contract with the HOA. These fraud cases were ongoing while Janae Reed was on the Hill Farms board. Remember, I said that was a conflict of interest for a member of the management company to be on the board of a company that they're managing. Did she inform the board that her company was successfully sued for fraud? Did she suggest that the board audit books kept by her management company when she was a director for CSS or for the HOA? Did she tell the board as a member her company was not enforcing many HOA rules? And as a board member, she would have known the HOA board was not holding required meetings and not keeping required minutes. I call it conflict of interest Exhibit A. Remember that the Hill Farms HOA is also a nonprofit organization and it is supposed to avoid conflict of interest. And here's a statement put out by the Utah Nonprofits Association. Members of the board of an ethical nonprofit act in the best interest of the nonprofit organization rather than on the basis of personal interests or the interests of third parties. Members sign a conflict of interest statement, declare all potential conflicts, and excuse themselves from discussion and voting on any matter from which they might gain personally. One management company offered this conflict of interest advice. As a board member, you are legally obligated to uphold your fiduciary duty to your HOA through your duty of care and through your duty of loyalty. You must act with integrity, exercise good judgment, and keep the association your top priority. Board members who are appointed by the developer during a community's development phase may feel split in their allegiances, but you are still obligated to look out for the community's interests, not the developers. In Hill Farms' case, the developers are the board members. Now about the Destination Homes president and CEO's conflict of interest. I call this conflict of interest B. Brad Wilson wears several hats. He's Destination Homes president and CEO, wearing the developer hat. He was an initial Hill Farms HOA board member. He's the current Legacy Neighborhoods principal. And he's a Utah legislator, Speaker of the House. It really is a mind-boggling conflict. It's bad that Wilson's development company set up the Hill Farms HOA to avoid board meetings, avoid notices of board meetings, and avoid making a record of board meetings. It's really bad that those violations of Utah HOA and nonprofit law are ongoing, even while he's a Utah lawmaker. But it's beyond appalling that Wilson, as a legislator, supported an extremely oppressive anti-HOA consumer law. It requires homeowners, upon taking control, to meet a list of burdensome requirements before they can sue a developer for construction defects and breaches of contract and fiduciary duty. It was called House Bill 157. At a legislative hearing on that bill, HOA attorney Curtis Kimball described the bill as onerous. When he spoke in opposition, HOA attorney John Morris at the same hearing called it one of the worst bills ever in connection with HOAs. A third attorney, Ted McBride, told legislators the measure is a step back in time, making it more difficult to pursue fiduciary claims. But Destination Homes co-founder, President Brad Wilson, voted for the measure during that committee meeting and again on the House floor. Wrapping up this presentation, I suggested that Destination Homes take steps to right its sinking ship before turning it over to homeowners. I got no response. I recommended the developer put an attorney or accountant homeowner on the board now to help create a law-compliant governing body and to prepare for the transition. Also, no response. I offered to show the board this video before I posted it. They declined the offer. If you have any comments, please email them to hoacomments@xmission.com.